Let us welcome our distinguished speaker, Professor Rishikesha Krishnan, who is the director of IIM Bangalore. He has been a fellow of IIM Ahmedabad, India, and he's a prolific writer with more than 140 publications spanning outlets that include refereed journals, the popular press, case studies, book chapters, and books. His main areas of interest are strategy and innovation. He has received the Thinkers 50 India Special Innovation Award in the year 2013, and his two books are very popular. The first one is From Jugaad to Systematic Innovation, The Challenge for India in 2010, and the other one is 8 Steps to Innovation, Going from Jugaad to Excellence, which he has co-authored with Vijay Olkar, and this book has received Best Award in 2013 to 14. We are lucky to have Professor Krishnan as one of the members of advisory board at SME, and he has done a number of talks and conferences, seminars, workshops, specifically in this area of innovation. So over to Professor Krishnan, and I unshare my slide. Yeah. Is it fine, sir?
Yeah, that's good. Thank you. Good afternoon. So let me see if I can share my slides now once.
Yes, sir. I think you can share. So you can see 68 attendees only, although there were more than 100 confirmed participants, but only 68 I can see.
Yeah, that's good enough. Can you see the slides now?
Yeah, we can see the slide.
Okay, so let me start then. Good afternoon. Thank you for inviting me to give a talk at this faculty development program. A warm welcome to all the participants. I think the way it is structured, the interaction has been kept towards the end. So what I will do is I will start with my presentation and then I will take some questions and interaction maybe after about an hour. So my presentation I have designed for about an hour. So let's go with it.
Okay, sir. So we'll unmute at the end of 1 hour.
Yeah, I think that should be fine. Okay. But of course, if it's required in between, I'll tell you. Okay, but hopefully it's not required until. Yeah.
Okay.
So the topic of my session today is IP innovation management. This is a pretty big area, and I'm just going to focus on a few issues. I'm looking at the link between IP and innovation management largely from a corporate perspective, not so much from an academic institution perspective. But at the end, if there are any questions on academic institutions, I'm happy to answer those questions. I'm sure you already had some discussion on this, but it's always important and useful to remember why we have intellectual property rights in the first place. I think the broad justification for awarding intellectual property rights is that if there were open copying and if anybody could exploit anybody's idea, then inventors would have very little incentive to innovate. Instead, inventors would tend to hoard all their information, and this would affect society adversely because ideas would not be available to others. And we all know that knowledge generation happens through a cumulative process. People build on other ideas, so we need to have access to others' ideas as well. So essentially, the intellectual property rights system tries to create a balance between the inventor and society. The inventor shares her or his ideas and gets exclusivity for a limited period in return. So society benefits from the knowledge of the inventors, and inventors benefit from getting some period of time in which they can commercially exploit their ideas. So it is this equilibrium or balance between these two notions that provides the basic framework for the IPR system. So now let's look at what is the challenge of managing intellectual property at the firm level. And to do that, we have to put it in a slightly broader context. We need to understand innovation by firms and what are the challenges they face in innovation itself. So if you look at several prominent examples of important corporate innovations over time, we see that there are lots of challenges that companies have faced. One of the most well-known centers for innovation in the late part of the 20th century was the Palo Alto Research Center of Xerox, where some of the core technologies which are critical for IT and related areas today, including the mouse, graphic user interface, etc., were created. But interestingly enough, Xerox Palo Alto Research Center and Xerox never significantly benefited from these inventions. Google created a very powerful search engine. And prior to Google, some of you would remember that the earlier search engines were not very accurate. Google was perhaps the first company to provide an accurate search engine. But Google took quite some time to figure out how to make money out of search, because they did not want to sell search directly. They were worried that the very act of selling search could contaminate the search process. And it was only once they created an advertising model uh, through AdSense that they were able to successfully monetize the new ideas they had created. Today, we all use mobile apps, but many of you would remember that prior to the advent of mobile apps, there were what were called mobile value added services, or mobile VAS, which were applications we had on our phones. But though these applications were developed largely by individual entrepreneurs and small teams, it was almost impossible for them to make money out of these inventions because it was the mobile operators who took away most of the money. Because at that time, the pre-app era, it's the mobile mass application creators were completely dependent on the service provider. There was no other way of accessing the user. Of course, on a lighter note, you will note that this problem has not completely gone away even today, because we've seen the recent controversy between Paytm and Google, where once again you're seeing some conflict between the app developer and the agency which is providing the app to users. And if you go to an industry like financial services, you will realize that innovations can be copied almost overnight. If a mutual fund or a bank creates a new product, it is very difficult to prevent other mutual funds or banks from replicating or linked to how do you get value. You create process improvements, you do business model innovation, you provide better customer experiences. But what happens if you're not able to get the value out of innovation? So this is where the intellectual property rights system comes in trying to help you appropriate value from the new ideas that you create. However, it's important to remember that the intellectual property system does not work in isolation, and no company can hope to derive value from innovation simply by relying on intellectual property. As this chart shows, there are three important dimensions which are related to the ability of a company to get value out of the innovation it creates. And when I say company, this could be an individual as well. So let me just spend a couple of minutes talking about this, because this is important as a framework or as a complement to the way we look at intellectual property. So if you look at the first vertical here, which is product market actions, you will see that companies get value out of innovation by things they do in the product market. For example, nobody has declared that Windows has to be the operating system for a PC. Yet we know that maybe 90% of the IBM compatible PCs that are sold in the world have Windows as the operating system. So Windows has become the de facto operating system for the PC, even though no standards body or any other agency has decreed that Windows is the OS. So it is the strategic actions of Microsoft over time which have enabled Windows to become the de facto standard. And this is one reason why Microsoft has a continuous annuity stream out of the Windows product. The second important way of getting value out of your innovation is to create barriers to imitation. Of course, intellectual property also does that, and I'll come to that in a couple of minutes.
Professor Krishnan, sorry to interrupt you. We cannot see the slide. If you are sharing your slide, nobody can see the slide. We can just hear you.
You didn't see any slides so far?
No, sir.
Okay, that's why I asked you right in the beginning.
No, initially it was there, and the participants are muted, so they are trying to say it in the chat.
Okay, let me share it again then.
Initially it was there for 5 minutes.
Okay, sorry. Let me go back and try again.
It's okay, sir. You can go continue from where you were there.
Okay, I think there's some other slide there. It has to be removed, no? I think that is why the slide disappeared. You need to remove the slide, whatever slide is showing up there. There's a slide which says, yeah, there's a slide which says NGOs or something.
We can see your slides now.
Okay. So just I think be careful on your side also. Make sure nobody changes any setting there, because you might have some rights which override what I have, and then whatever I have will disappear. Anyway, it doesn't matter. So I'm not going to go back to the earlier slides. Let me just focus on this one. So let me just quickly repeat what I said just now. Maybe one thing you can do is you can unmute everybody. How does it matter? So that if in case and if they say something, we'll also know. But anyway, I leave it to you what you want to do. So I was basically saying that there are three important ways the Intel processor. So this is a way in which Intel is creating barriers to imitation for others. There could also be collaborative agreements between companies. We've seen that in new technology areas. Often when there's a new standard to be created, companies come together to collaborate and create those standards. And that's another important way of creating a barrier to imitation. The second important stream of actions which help you appropriate value of innovation is what we might call continual innovation, which is the second column on this slide. Where essentially, if you want to get value out of innovation, you can't just do an innovation once and hope to benefit from that. You need to continuously improve, Sometimes you even need to cannibalize your own products. Another way of getting more value is to use the philosophy of a platform where you create a basic technology or configuration and then adapt that to different users' needs. And of course, finally, you sometimes need to do radical innovation in order to be seen as an innovator. A good example of this last point is Toyota. You would recall that Toyota has always been very good at manufacturing, but it never quite got the same respect as some of the automotive manufacturers till it created the Prius, which was the first commercially successful hybrid car. The advent of the Prius established Toyota as a company that was a good innovator, and this in turn enhanced the brand image of Toyota and also enabled them to sell other vehicles in much higher volumes and at better prices and so on. So in addition to the last column, which is the intellectual property strategy, the point I'm trying to make is to get value, you need to look at product market actions, you need to use continuous innovation. And then, of course, finally, you have all the intellectual property approaches. You could use patents, copyrights, trademarks as appropriate. And of course, under certain conditions, you might want to just keep your ideas a secret and hope to protect it as a trade secret. So all of these different methods are often used in combination by companies. For example, if I'm Intel, it doesn't mean that because of the Intel Inside campaign, I don't patent. Of course, I patent, but I also use other methods like the Intel Inside campaign to get the best value out of my innovation. Similarly, if I'm Intel, I don't sit quiet because I've produced the next generation chip. I'm continuously improving that chip as well as planning the design of future generations of chips, which will be even better than the existing one. So one of the important frameworks which is related to this whole question of how you get value out of innovation is the framework I'm showing you now. This is called an inimitability and complementary assets framework. This was originally developed by David Teese, but the one I'm showing you is adapted by Afua. So what you see here is there are two important axes which help you determine whether you will get value out of innovation or not. The first axis is the x-axis, that is what is the importance of complementary assets and who controls them. And the y-axis is how easy is it to imitate. Once I give you some examples, this framework will become clear. Let us look at the left-hand side bottom box. What the left-hand side bottom box is saying that if the ease of imitation is low, which means essentially that others cannot copy, then as long as the complementary assets are easily available to the inventor will be able to make money because others can't copy, but he has access to the complementary assets like manufacturing, regulatory approvals, all the other things that are required. Therefore, he doesn't have a problem in making money. So this is true of most, distinct technology kind of products. Let us come to the bottom right-hand box, where the ease of imitation continues to be low. Maybe it is covered by intellectual property and other protections, but the complementary assets are important. For example, distribution is difficult, or there are certain key other assets like maybe cartoon characters which belong to certain other parties. The good example here is the company which Steve Jobs started called Pixar, which was in the animation business. Initially, they were, of course, trying to be on their own, but then they realized that they needed access to some of the well-known cartoon characters, many of which were controlled by Walt Disney. So finally, they decided to do a partnership with Walt Disney, and ultimately, of course, Disney bought Pixar. So essentially, in this box, you need both the complementary resources as well as control over the invention to make money. If I go to the top row and the top left-hand box, you will see that ease of imitation is high. Here I don't have any IP coverage, or the IP coverage is not very strong. Others can easily copy, and complementary assets are also easily available. This is the box where it's very difficult to make money. So startups which get into this box often don't make good returns because it's very easy for other people to copy what they have done. However, the other interesting box is the top right-hand box, where imitability is high, but complementary resources are important. The best example of this is the soft drink industry, where typically a lot of the new ideas have come from small players, but intellectual property protection of such ideas has been weak. And instead, the people who have made money are the large soft drink brands like Coke and Pepsi, who have copied the ideas of the small players and taken them to the market. So just keep these in mind, because these are important broad frameworks which help us understand the importance of intellectual property in innovation management in a better way. So I'm just moving on now to look more specifically at intellectual property. And here I'm going to try and link intellectual property, innovation, and the strategy of the firm. And the reason I'm linking these three is because in companies, typically innovation is very closely aligned to the strategy that the company follows. For example, if I'm trying to develop very cutting edge blockbuster drugs, then I need to be very intensive R&D player. On the other hand, if I am just doing generics, my focus may be on process R&D and not creating new drugs. So the whole question of what your innovation focus is varies depending on what your strategy is. So what I'm going to present in the next few slides is based on an excellent article written by Rivet and Klein in Harvard Business Review. It's an old article, but its content remains relevant even today. What this article basically says is that if you manage patents strategically, this helps you in three ways. It helps you establish a proprietary market advantage, it helps you improve your financial performance, and it helps you enhance your overall competitiveness. How do these three things happen? Let's start with establishing a proprietary market advantage. Now, this is at the core of IP, and this is at the core of the link between IP and innovation management. We know that typically companies take patents to protect their core technologies and business methods. Xerox enjoyed a monopoly in the photocopier business for close to 2 decades, thanks to the dense coverage of patents which it had over the core xerographic technologies. More recently, Dell, which is not a great technology innovator, has 42 business method patents which it used in creating a cross-licensing deal with IBM. Of course, this is also some years ago. You could also look at developing products based on your patentability, and that's where another link happens between strategy, IP, and innovation. For example, Hitachi develops only those products for which patents can help it get a dominant market share. So if there is no potential for patenting and enjoying a prime position in the market, Hitachi would not like to go into that product at all. Gillette is a company which does extensive patenting and follows this strategy, and I'm going to give you an example in just a moment. So if you look at this particular picture, this shows the Gillette Mac 3 razor. And many of you might have seen this razor. It is sold widely in India. There are 57 US patents covering this Mac 3 razor. And this slide shows you a list of all the patents which cover this particular product. Every single element of functionality of this product is covered by intellectual property, whether it be the assembly, the blade geometry, the shaving strip, the contact and comfort, the guards for tactile sensation, the surface for engaging the skin, the whole process of aqueous cleaning of the blade, everything is covered. So you can just see the elaborate attention which Gillette pays to getting patent protection on a product like this. In doing this, essentially companies follow two strategies. The last point on this slide. One is they try to create a patent wall, which we just saw an excellent example in the case of Gillette. The other is they also follow a process called bracketing. Bracketing is more trying to prevent others from getting more value out of their patent. For example, suppose a bulb manufacturer develops an excellent new filament. Then other bulb manufacturers may try to prevent that company from exploiting its filament technology by taking patents on a lot of the complementary technologies which go with that new filament. For example, improved glass or the shape of the shell, etc. So that's how bracketing works. So techniques like clustering and bracketing are used by companies to boost their R&D and brand effectiveness. You could also use IP in your strategy to anticipate market and technology shifts. For example, Texas Instruments bought a company called Amati Communications for close to $400 million to secure DSL patents when they could see that DSL technology was going to become very important. So they wanted to control all the key patents in the area, and therefore they acquired this company for this purpose. The second important dimension of using patents in your strategy is to improve your financial performance. One interesting thing is that many companies have thousands of patents. You take a company like IBM, which gets more than 9,000 patents a year. They have a huge patent portfolio. But many of the patents they have, they may not be commercially exploiting because maybe those are not integral part of the products or services which are in their core product or service basket. So then there is a huge opportunity to license these technologies and to get alternate revenue streams. Companies like IBM earn more than $1 billion a year from licensed revenues. And sometimes there are good opportunities in buying out the other companies which have not discovered the value of their patents. Look at this last example. ST Microelectronics bought a company called Mostec for $71 million and within 7 years got more than $450 million on licensing revenues based on the technologies which this company Mostec possessed. So you could see that Mostec was not really aware of the value of the technologies it owned, and STM saw that value and was able to exploit it by paying very little to Mostec, but then using those patents to generate a lot of licensing revenues. Of course, you can also try to improve your financial performance by not necessarily continuing patents that are not giving you value. Companies like Dow Chemicals do periodic reviews of their patents in order to weed out patents which don't have future potential. You can also use your patents to create new businesses, to spin off new ventures, to securitize your patents. Sometimes you can use it to push up your share value as well. And finally, last but not the least, there is the whole issue of how do you manage your competitiveness using IP. Look at this first example. A company called S3 outbid Intel to buy another company called Exponential Technologies because that helped it get access to a prior patent, and it used that prior patent to force Intel to enter into a cross-licensing agreement in the high-performance graphic chips business. So S3 realized that when it went into this new area, they would need access to some of Intel's patents. They didn't have enough bargaining chips of their own, so they bought this other company, and that gave them the bargaining chips to actually negotiate much better with Intel. Sometimes it will also help you exploit new market opportunities. Guidant received FDA approval for a new stent. J&J patent infringement. What did Guidant do in response? They bought another company called Endovascular because Endovascular had patents that predated those of J&J. So now they had a strategic tool to manage the competition with J&J in a much better way. Of course, there's also the issue of risk. If you ignore patents or don't take them seriously enough, you do that at your own peril. Kodak ignored Polaroid's patent thicket and paid nearly $1 billion in damages and had to shut down a $1.5 billion plant. So you can see these kind of challenges also emerge. And of course, at the same time, you need to be careful because sometimes another company taking a preliminary injunction against you can virtually hold you to ransom. So there are companies called patent trolls, many of you would know that, whose business is just to hold patents. Here's a great example. There was a company called NTP, which was a patent troll, which filed against the parent company of BlackBerry for violation of 5 patents. The judge seemed to be likely to grant NTP's prayer for an injunction. And RIM was desperate because obviously if there was an injunction against their service, the whole BlackBerry system would crash. RIM settled 1 week later for more than $600 million, even though they could have challenged NTP's patents, but the whole time involved simply made it impossible for them to do so. So these are some of the challenges in playing the entire patent game. Of course, there are also limitations of patent strategy. There are several patents, several challenges. The first one is obtaining a patent takes time, it costs money. In the process, you have to disclose your invention. Remember, that's part of the deal we talked about between the inventor and society right at the beginning. Patents have national boundaries, as most of you would know, so you need to have patent protection in every jurisdiction where you want to have commercial exploitation of your idea. Infringement is not easy to prove. It's often difficult to prove. So even if you think somebody has infringed your patent, it's not always easy to prosecute them. And of course, it can also involve long drawn legal proceedings. Just to give you an example, this is a very celebrated example in the history of IP. This gentleman, Robert Kearns, he is the one who invented the first intermittent windshield wiper for cars in the early 1960s. He filed his first patent application in 1964. He tried to license his technology to the large auto companies, but no one took a license. The majors introduced their own wipers with the intermittent windshield wiper concept 5 years later. Mr. Kearns filed patent suits against Ford and Chrysler. He eventually won the suits, but by that time he had almost gone crazy. His family had also broken apart, so you can see that he paid a high cost in order to defend his patents. And if you're interested in seeing a good account of this, there is a 2008 movie called Flash of Genius, which portrays the travails of Robert Kearns extremely well. So these are some of the challenges you face in prosecuting a patent strategy. So Professor Vinita, I'm just going to change my approach a little bit. I think I'm going to stop at this point of time before I go further and maybe just answer any clarifications, because if people have got any doubts, it's good to, I think, clear them right now before going on to the next slide. So if you can unmute, maybe we can take some questions now and then go forward.
Professor Krishnan, Mr. Dhananjay Singh has a question for you. He says Joseph Stiglitz says that patents tend to discourage knowledge propagation, not so much with copyrights, TRIPS being discriminatory to developing countries. He would like to have your views on this, please.
Yeah, so that's a very big question. If you don't mind, I will take that question a little later. I'm going to talk about IPR issues in India, and TRIPS is going to come up there. So with your permission, I will just postpone that question to a little later in the presentation. And at that point of time, if I don't answer it properly, you please remind me. Any
Anyone
other
else?
question?
So why there is so much of delay? Hello, sir, this is Amaleshwari. So why there is so much of delayed process in getting it patented, sir? Because you very clearly explained the process and this case of Mr. Robert. Why there is so much of delay in patenting legally?
Okay. See, I think when you first file an application for a patent, typically there is a patent examination process. So at least in India, and it's true in many other countries, the patent office has a limited number of patent examiners. And these patent examiners have to review a large number of patents. So the first delay happens there itself, because the patent examiners take quite some time to decide whether the criteria of patenting are met and whether patent should be granted or not. And once that backlog starts building up, it becomes quite difficult to address that backlog. Of course, that is one part of the story. A lot of the subsequent delays come only if there are challenges. So typically, I think in most jurisdictions, patent award may happen in 18 to 24 months. In India, maybe it will take a little longer. But after that, there is a possibility that somebody might challenge your patent. And these challenges can go on, unfortunately, for quite some years. In some countries, they have tried to address this problem by setting up specific courts for intellectual
Faster
property
track
matters.
court.
Yeah, like in US and so on. So those they have a specialized courts that helps a little bit. But otherwise, if it goes through the normal civil court system, it can take many years. That's what tends to happen in India. Any other question?
Thank you, sir. Thank you.
Any question about any of the slides which I presented?
Right now, I think there were two questions. One you have taken up, and the other one you have postponed.
Okay, fine. So we'll go forward then. Thank you.
Okay, sir. Thank you.
Okay, so the next important thing to realize is that patenting varies across industries. If you see this chart, I'm sorry the font is a little small, so I will read it out for you. This is the list of 2019 top 50 US patent assignees. That is, these are the companies which got the maximum number of US patents last year. IBM is number one with 9,262, followed by Samsung, Canon, Microsoft, Intel, LG Electronics, Apple, Ford Global Technologies, Amazon, Huawei, and Qualcomm. So you will notice a few things about this straight away. First of all, the largest number of companies in this list belong to the US. The second largest number perhaps comes from Korea, is it? I guess. So you have both Samsung and LG. Then you have Canon, which is of course a Japanese company. You have Huawei, which is a Chinese company, and the others are all American. IBM and Microsoft, Intel, etc., are all American companies. The second thing you'll notice very interestingly is that most of these companies are in the broad IT and electronics kind of domain. You don't find companies from other domains. In fact, Ford Global Technologies, I think, is also focused largely on automotive new technology. So it's not on the traditional technologies. So all of this has to do with electronics, IT, etc. And of course, Amazon has a good number of business method patents as well. So so you can see that even though, for example, the pharma industry is a fairly large payer of patents, the pharma industry does not figure in this list of top patent awardees. And you'll see, of course, as I mentioned earlier, that the top patent awardees are located in a few countries where there is significant investment in R&D and a very strong environment supporting high technology development. So that's something which is interesting to remember and just keep in mind as we go forward. One important question for companies when they are looking at the link between IP and innovation management is what kind of approach should they follow for intellectual property? Should every company be trying to patent every invention that it creates? Or should they only choose certain ideas for patenting? How should they go about this process? So this is an important chart because this tells you a little bit about what companies need to do in order to and to generate premium returns or better prices on their products. The ones on the left are more focused on reducing cost, so they are more focused on efficiency, and therefore their key aim is to focus on reducing the cost of other people's intellectual property to them. So let's look at this in detail. So look at the bottom right hand corner. Bottom right hand corner, says that the company is trying to achieve a price premium. It's trying to achieve product differentiation. It wants to create and protect its markets. Therefore, it's very aggressive in IP protection. I gave you the example earlier of Gillette taking 57 patents on one of its products. So this is a company which would traditionally fit in this bottom right-hand box. Let us go to the right-hand side top box. This is probably an example of something like the semiconductor industry. The semiconductor industry also wants to use technology, but the problem they face is that there is a lot of overlap between technologies. If I'm developing a new chip, there is a good probability I will be infringing the patent of some earlier chip developers. So even though I might have some new idea, I still need to take permission from earlier patent holders. So you'll see the top right hand box talks about securing cross licenses. That's permission to use the technology and patents of others. They negotiate joint ventures, technology transfers, and commercial agreements, and they are focused on generating royalties. But again, their overall goal is to make more money out of technology. Now let us come to the left-hand side. The left-hand side, as I told you, is companies which are largely focused on efficiency, on lowering costs. So the left-hand bottom corner, I'm essentially trying to prevent anybody from stopping me. I want to settle any litigation fast. I would in fact prefer to avoid litigation altogether. Basically, I don't want anybody getting in my way, but I would look at patenting as purely defensive. I am not trying to make money out of patents. I would only hold some patents to prevent others from dictating terms to me. And if you look at the left-hand top box, here I'm more proactive. I want to assertively deter others. I would like to reduce royalties. If possible, I would like to eliminate royalties altogether. So I would have, again, IP largely to keep my path clear. Basically, what in IP terms you might call freedom to operate. Freedom to operate is what I'm seeking, not necessarily to make huge amounts of money from my own IP, but certainly prevent others from holding me up. So the point I'm trying to make here is a simple one, that depending on your strategy and depending therefore on your approach to technology and IP, the way you look at patenting would vary from one company to another. What is the process followed inside a company? This is also important, because remember, we are saying that companies have to decide when to patent. So suppose you have a lot of people in your organization who are working in different areas. They might be coming up with ideas, but how do you ensure that those ideas are reviewed properly and acted upon from the point of view of getting intellectual property protection? So what is shown in this chart is a typical IP and patenting decision process. It starts with what is called an invention disclosure. So in most companies which are serious about patenting, they have a format which is required to be filled by employees every time they come up with a new idea. And the employment contract requires them to disclose any such new idea to the employer. This invention disclosure form usually has details of the novelty. It also talks about the possible commercial value, and it contains an assessment by the inventor of why this should or should not be patented. Usually this invention disclosure is then considered by some kind of a coordination committee, which gets recommendations from a patent attorney, from the engineering manager, from evaluation guidelines, even from a general manager survey if required. And then finally a decision is taken. Should we file? Should we just maintain it as a trade secret? Or should we proactively publish the information in the public domain so that we preempt patenting by others? These are the three possible options. Of course, there could be a fourth option which says do nothing, which is also a possibility. If you believe that the idea is of very little value, you may choose not to do anything about it. So companies which are strong on R&D, like the companies I showed you in that list of top patenters, They all have very sophisticated disclosure and review processes. These days, all these are automated, so it's easy for them to follow up and track what's happening to different ideas. And then, of course, if once the patent is filed, they continue to track it after that, because over the lifetime of the patent, they would have to take various defensive as well as offensive actions to protect the value of the patent they have filed. So this is a very important part of how intellectual property is managed in practice within companies. At least from the patent filing side, it is managed largely through the invention disclosure system. As I mentioned earlier, the deciding what to do with the invention depends on your product and technology strategy. It would depend on possibly the competitive environment. What is the cost and time required for getting the patent? Obviously, the cost and time has to be commensurate with the benefit that the company is going to get. Then there are questions of whether you are likely to be granted a patent at all. Is there prior art? And if so, how does that come into conflict or possibly help you in your patent filing? What will be the impact of public disclosure? Will this help you or harm you? Not to proceed, what steps do you need to take to prevent competitors from coincidentally pursuing a patent protection of the same invention? That's what I mentioned earlier. You could choose to publish, or you could choose some other method to put it in the public domain. Okay, let me once again stop here for a moment. I think if possible, we can see if there are any questions before I go forward.
There's a question from Shailaja Hiremat. She says, IP or patenting to yoga, how do you see it as a knowledge to be patented by India?
Yeah, see, things like yoga and so on are difficult to patent now because, first of all, yoga has been in existence and practice for years, so it's common knowledge. It's very difficult to say that it is non-obvious or novel or any of the other criteria which are required for patenting. So many of the traditional art forms and so on generally cannot be patented at this point of time. So even if somebody grants a patent, it's not correct in my view. So I think traditional knowledge needs different kinds of protection, cannot be protected through the patent system. In India, we have something called a Traditional Knowledge Digital Library, which is maintained by CSIR, which is trying to record existing historical knowledge as a way of preventing people in other countries from taking patents against this. So that's one repository you could look at if you want to see what prior knowledge exists, and also if you want to protect something which you don't want somebody else to wrongly patent.
Naveen Shaw, you have your hand raised. Do you have a question? If yes, please unmute yourself and ask.
I don't think Naveen Shaw sir is having any question. He's not aware because that hand is raised since the beginning, and I've written a message to him.
Okay.
There's another question. India seems to be laggard in patents and IPR. Like you shared list of companies and no companies present in the list. What do you suggest to various entities to improve situation?
I'm coming to that. There's an India section, and along with that question on TRIPS and all that, I'll take it in the India section.
Okay. Yeah. Another one is why there is insignificant patent filing by Indian institutes vis-a-vis global institutes.
Okay, we'll talk about that also later.
Okay.
So let me go forward, I think.
Sure.
Now, one of the interesting ideas which has been talked about a lot in recent years is this question of what is called value transference. See, all of you would know that IP has a fixed life. Patent typically is 20 years from the date of application. You would have copyright, which of course has longer applicability. Trademarks, at least in theory, can be extended and renewed multiple times. Of course, patents, trademarks, and copyright are not substitutes for each other, but a lot of companies use them in very smart ways in order to manage IP across the entire product lifecycle. So let me give you an example. So this is a concept called value transference. The concept is refers to the premeditated use of multiple intellectual property methods at specific points across the product life cycle in order to realize sustainable differentiation. So what it means is that you need different kinds of IP protection at different points in the product life cycle. So maybe early in the life cycle, you want to secure functional differentiation. That's the time you use patenting. But later in the life cycle, you would use things like trademarks. For example, you would use a trademark to secure the critical design elements central to the cognitive touch points like shape, color, sound, etc., where you want to build an association between the patented aspects of the offering and something that's not necessarily linked to functionality, as I said, like shape, touch, smell, etc. Let's look at an interesting example of this. Let's look at value transference applied to the Apple iPod. Of course, the iPod itself is no longer sort of really a hot product. It's got replaced by the iPhone, and most people today don't have a separate device for music. But if you just rewind in time, you will see that Apple had a very interesting design strategy for the iPod. It was a very clean looking product. It had very well-defined form, features, and functions. Apple's goal was to build brand identity through great design, but also to leverage and secure critical design elements and cognitive touch points through non-traditional methods, so that they had a strong transferable brand identity across the product life cycle. So the interesting thing about a product like the iPod was if you had taken it apart and looked at what was inside, you would have found a whole set of proprietary technologies which belong to other owners. For example, you would see companies like Sony and Samsung and TI and others had IP inside the iPod. Not surprising, because Apple did a lot of its design in terms of integrating components from other companies. So where iPod tried to essentially protect its IP was through design patents. A lot of the design patents were, of course, around the unique form factor of the iPod. And you can see that clearly in the evolution of the iPod design in its early years, as shown in this chart. So as the iPod form evolved, you can also see that it kind of took a distinctive shape, which is represented in the bottom diagram in this slide. And they therefore started taking trademarks around this shape, and of course also used it to cover a whole lot of aligned products, as you can see in this trademark application, which is related to portable and handheld digital electronic devices for recording, organizing, transmitting, etc. And then they used that trademark and adapted it to make another trademark called Made for iPod, which was essentially a way of certifying products which were approved for use with the iPod, like stands, and you can see an interesting stand for the iPod, and then you have things like iTunes, the iTunes Wear, etc. So you can see that Apple used patents, they used a trademark to represent their own product, they used trademarks to define the associated or related products which could be certified to go with the iPod. They used all these different methods in order to protect the core IP which was related to the iPod. Okay, so that's just to give you an idea that, companies don't use patenting or any one technique in isolation. They link the techniques together across the product life cycle to give themselves protection in different forms at different points of time. Okay, so now let me come to the issue which many of you have been concerned about, which is intellectual property in India. Let me start by just giving you a little bit of a background. So again, my focus here is largely from an industrial perspective, but I'll talk about academia and research institutions as well. If you look at the evolution of Indian industry, and here I'm going back about 70 years to the time India became independent, you will see that for a long period of time, India's focus was on process innovation and process improvement with the objective of reducing cost. And this has been the traditional focus of Indian companies. So if I just look at the sequence of activities which Indian companies have followed, it is roughly similar to this chart, which is based on a framework developed by Forbes and Wheel some years back. So Indian companies first learned how to produce. Let's take a simple example. Let's take Indian steel industry. So India set up steel plants in the 1950s and 60s in places like Rourkela, Bokaro, Bhilai, etc. And for all those steel plants, we did not have the know-how how to produce steel. So we borrowed and sourced the technology from other countries. And our first challenge was how to make that technology work in India, because we didn't have the skill sets, we had different weather conditions, we had different quality of raw materials, etc. Once we had figured out how to make those plants produce, the next step was to produce efficiently, which is basically to look at the ratio between input and output. For every ton of iron ore which I use, how much steel do I produce? For every ton of coal that I use as a source of energy, how much steel do I produce? So the idea was to get to world-class standards on efficiency. So there was a lot of process improvement, which is what I talked about in the previous slide. And then finally, of course, at some point of time, we came to the objective of trying to become world leaders in certain areas, not in all, but in some, where we were trying to define the new processes. But that didn't happen in too many industries. And of course, maybe from the 90s onwards, you will find that we got a little more into the product domain. We started, for example, creating value-added steel, special steels, things like that. And then, of course, you come to the last box where we are saying we are creating completely new products. So this is the sort of progression which India followed. Now, remember, if you're doing process innovation, you may not have a whole lot of product patents, because the patents you would get, if at all, related to the process. And you would also realize that many times you may not choose to take a patent because you don't want that information to go out. So you would probably try to keep your improved process as a trade secret. So for a long time, process was the mainstay of Indian innovation, therefore patenting was not high. Product innovation is of relatively recent origin, and we have seen very few high-profile patent disputes. Globally, we see them all the time. For example, Apple and Samsung and Qualcomm and all these big companies are having a whole series of disputes with each other. But in India, we rarely see that, because Indian companies are not at the forefront of product innovation. There have been a few examples. One example is in the motorcycle industry, where Bajaj developed a bike called the Pulsar, based on a technology called DTSI, Digital Twin Spark Ignition Technology, which it developed with a Japanese R&D consulting company called Tokyo Design and Engineering. They got an Indian patent on the core DTSI technology, and they used this patent successfully to prevent TVS from launching a bike called Flame in 2007 on the grounds of patent infringement. They actually managed to get an injunction. You remember I talked about injunctions right at the beginning of the talk. And finally, of course, this went to the courts and so on, but Bajaj successfully prevented TVS from entering with a new product. But this is one of the, I would say, very rare cases in India where we see patents becoming a significant weapon of competition in any of our industries. Of course, I should say, and this is the third point on this slide, the biggest arena of IP in India has been pharmaceuticals. As many of you would know, this was originally driven by the Patents Act of 1970, which did not allow product patents in certain domains, particularly in drugs and pharmaceuticals. As a result, Indian companies started focusing on developing new processes for existing patented drugs. And this is what enabled them to become very strong in the generics business. Later on, they used certain opportunities in the US, what is called the Hatch-Waxman Act, which allowed certain priority for the first generic producer who could come in with a product that did not infringe the original patent. So many companies like Dr. Reddy's and others use this provision to launch products in the US. To do all this, they had to understand US patent law very well. They also had to get patents of their own. So pharmaceuticals has been the largest arena for patenting in India. And even today, the largest patent awardees in India tend to be in pharma, unlike we saw globally where it's largely electronics and IT and so on. In recent years, the automobile industry, particularly the two-wheeler industry, has been a hub of patenting activity. We have three big companies, Bajaj, TVS, and Hero, and together they are they constitute the largest motorcycle industry in the world. India motorcycles account for about 38% of the global motorcycle market, and these three companies have been doing fairly good amount of patenting because they are also investing quite a lot in R&D. Awarded per year to Indian inventors was just 62. So that's a very, very small number, as I'm sure you will appreciate. Post the TRIPS agreement, it went up from 62 to 375. And opposite, 90% of the patents are awarded to Chinese nationals and about 10% to foreigners. It's exactly the opposite of what it is in India. So you can see that there is a big challenge here as far as technology development and patenting is concerned. So now let me try and recall the questions. One question was about TRIPS and Stiglitz. Yeah, it's an interesting question. You can think about whether TRIPS is helpful or not helpful. If you ask Indian pharmaceutical companies, they were initially skeptical, but once they started becoming part of the global pharma industry, they also became relatively strong supporters of patenting because a lot of the advantages they had, for example, in the US market were because they were able to get patents around some of the processes they had created. So you can say the jury is out whether TRIPS has benefited India or not, but you can see the numbers. Indian companies have not really managed to capitalize to that degree. But this is also partly because of the industries in which they are. Just remember the industry chart I showed. Semiconductors, etc., where the bulk of the patents are filed. If you don't have presence in those industries, you will also not have a large number of patents. You also asked a question about Indian academia. well, Indian academia, I think, has not been very sensitive to patenting in the past. But just remember that just taking patents by itself doesn't help you much. If you want to get value out of patents, you have to then look at who is possibly infringing your patent. You have to then track them. You have to do litigation against them. It is a big job, and it requires a full-fledged office to do that. Some Indian institutions do have a technology office, but most of them don't have the resources to do all of this on a large scale. In India, the largest awardee of US patents is CSIR. CSIR is the only organization which has the resources to do all this. But smaller technology institutions lack the resources to pursue this on a global scale. So let me stop here because I think there were a lot of questions about India. So maybe I can answer those questions before going forward. Any questions?
Yeah, there seems to be one question from Naveen Shaw. This is a very generic one. For a startup in R&D, the process of filing patent and then complying to all the regulations and follow may be an extra burden. Is there any government support for them? Of course.
Yeah, there are a lot of schemes. In fact, under the startup program of the government, there is extensive support. There is also a fast track process for granting. Many incubators also have support programs. So I think that situation has certainly improved a lot in the last, say, 5-6 years.
Professor, there is another question. How does IPR impact MSMEs in India? Your views, please.
So unfortunately, MSMEs have not been much, or I should say very active in the patenting domain. Sometimes in the early phase of their development, when they are new companies, they sometimes develop new technologies and products, and then they sometimes manage to exploit or commercially use those patents or technologies which they have developed. But in general, MSMEs, I am sorry to say, have not been very active in the technology and patenting domain. Of course, there are exceptions, but this is a very broad general statement. Many MSMEs have historically worked as ancillaries to large companies, in which case they make products and technologies to suit the need of their client, which could be, say, public sector like BHEL or a private company like Tata Motors. In which case, often the design is provided by the customer and not necessarily as per the design of the supplier. However, there are some tech companies, maybe in Pune, Bangalore, to some extent in Chennai, who have developed products and technologies of their own, and they have taken IP protection in the form of design registration, and they are trying to get value out of that IP. But in general, one would be sorry to say that MSMEs in India are probably taking intellectual property protection below their potential. To be fair, one should also admit that Indian legal processes are very slow. So if you get protection also, your ability to use the legal system to prevent others from copying is quite challenging. So it's not an easy job. That much I can say for sure. Yeah. Any other question?
Yeah, Amit Budhi Raja. Non-monetization or cumbersome process of monetization patents acts as for discouragement for patent inclination towards patent filing. Is what you are trying to convey? Non-monetization.
So I'm actually putting it the other way. I would say that if you are patenting, you also need active follow-up. So of course, there are other agencies which can help you. Sometimes you could even get another organization which is interested in buying off your patent if it's something really valuable. For example, there's an organization called Intellectual Ventures, I think it's called, which has been trying to buy the IP from some of the Indian technology institutions. So there are third parties like that who might be willing to pay you for your IP and then try to commercially exploit them. But yes, it is a full-fledged activity which requires to be managed like any other activity. So if you want to get value out of IP, you have to invest in all these things. So one thing I can say is it probably makes sense if you have a certain minimum scale, or if you have a technology that's so good that even at a small scale, it's worth your pursuing and getting the value out of it. But of course, I showed you the Robert Kearns example. It can be difficult if you are a small company fighting huge giants who have a lot of resources to play legal games, which you may not have.
Professor Krishnan.
Yeah.
Hello.
Yes, please.
Professor Krishnan, to the answer that you gave to the SME sector in India, whether the SME sector or the micro, small, and medium enterprises who are primarily in the manufacturing, and the export sector, and give employment to the large workforce. So, is the IPR regime a factor anywhere for them to create create employment, or it is not mattering much? That is what I could get from the discussion. Since they are at the lower end of the value chain, so it doesn't make much difference. Is it like
You
that?
could say that, but there is, so it works both ways. What you say is probably true because you are not making cutting edge products. Many of the things you are doing may be off patent or not part of the patent system. But that also means that your value added may not be very high. So, it cuts both ways. So you're right, it may not come in the way, but it also means that the kind of return you get will also be very low. So if you really want to enhance the kind of value your products or services create, some intellectual input, and particularly if it is protected by some IPR, may help. Because obviously people like investors and venture capitalists and so on, they certainly look at whether you have any IP, particularly if they are looking at valuing your company. But yeah, I agree, at the very, very low end where you're only producing undifferentiated products, their IPR may not have much role to play.
There's another question from Salja. She asks, what are IPR issues in e-marketing, as a lot of digital content processes are being used by companies? So this is a very
That's the next section. So my last section is innovation and IP in the digital era. So we have a few minutes left. I won't cover e-marketing specifically, but I'll tell you some of the broad issues in the digital arena.
We still have 12 minutes.
Yeah, I'll cover that now. Yeah.
Sufficient time. So should we go ahead, or you want some more questions? Professor Rishi?
Yeah, we can go ahead. I'll go ahead. Sure. Okay. So this is the last section which I wanted to cover, which is IP and innovation management in the digital era. So, this is, of course, an emerging area. First thing is, of course, digital technologies have broadened the scope of innovation itself, whether it be product, process, business model, whatever it is. Digital technologies have really widened the scope. We know that the first major impact was in products that could be digitized, like music, books, movies, etc. Then, thanks to sensors and Internet of Things, machines and devices have become quasi-digital. Services have also been impacted. Earlier, if a car insurance company wanted to calculate the premium for a driver, they had to use proxies like age, gender, occupation, etc. Today, they can put a chip in your car and they can observe your behavior and then determine what is the premium you should pay. When you add artificial intelligence and machine learning, of course, now you have even more potential for enhancing the kind of features and so on. You can embed intelligence, products can potentially self-learn, etc. And there are all these opportunities to use AI and ML. For example, there's robotic process automation. There is a whole lot of new techniques which are allowing you to improve manufacturing and removing scale and cost trade-offs. The biggest impact is one would expect is going to be from artificial intelligence. This is not a presentation on AI, so I'll not go into much detail, except to say that AI influences innovation in two ways. One is it's a technology in itself. The second one, it's a method of invention. So when both of these combine, it tends to enhance the scope of innovation manyfold. And therefore, AI is expected to play quite a big role in innovation going forward. There's enough evidence of this. Many companies have shifted a lot of their R&D budget to using AI and machine learning extensively in the new products and services they are creating. We also, of course, live in an experience economy. And of course, a lot of this has to do with convenience. Of course, but thanks to COVID, some of these things may not be so active. But pre-COVID, this was the case. Then we have things like bots and virtual reality and so on, which are enhancing experiences. There is business model innovation. And of course, a lot of automation is now going on beyond automation to what they call augmentation. But the more interesting question is, what is the implication of all this for IP? So there's a very interesting interview with the Director General of the World Intellectual Property Organization. The link is given on this slide. You can go and refer to it later. But I just want to spend a couple of minutes talking about this. So one of the questions which he is trying to answer is, do the existing intellectual property rights provide the incentive required for innovation in the digital age? You remember we talked right in the beginning about how IP rights are closely linked to creating incentives for new ideas to come out. So the question is the IP system well geared for all these new developments in AI, ML, etc.? How technologies that dominate in the digital economy? The DG says this remains unclear. Remember that things like AI don't happen in isolation. Economic significance. So you can think of the huge data which internet giants like Amazon or Facebook or any other similar company are sitting on. And the question achieve them. And of course, you would also know that it's not only about IP, there are other regulatory regimes. For example, there is the General Data Protection Regulation of the EU, which is already providing a challenge to AI because driven economy using AI and machine learning as a primary mode of innovation, the IP issues are quite unclear at this point of time. So I think in the next few years or next decade is going to we'll have to wait till many of these issues get cleared up and clarified before we'll actually be able to understand, how all this is going to be tackled in the new economy. So let me stop here. That ends my presentation. I'm happy to take a couple of quick questions, if any. And after that, we can close. So any quick questions?
Yeah, there are 2-3 questions more. In India, is there any difficulty to get patent? I didn't get this question. In India, is there any difficulty to get patent? Venkata. Mr. Venkata, could you please elaborate it? What you wish to ask?
Okay, I'll answer the question anyway. So I think the main difficulty in getting patent in India is that it takes time. Generally, processing time in India is a little above the global average. So that is the biggest challenge you face. Of course, remember, as I said right at the beginning, you need patent protection in every jurisdiction where you compete. So it's not enough if you get patent protection only in India. You also need to get patent protection elsewhere if you want to have protection in those markets. So getting patent in India is not enough.
Sir, another question is, recently I spoke to a business owner who was into manufacturing UV radiation machines. And now during COVID, he's manufacturing UV sterilization machines. He developed it by seeing some machines on net. He said he was able to manufacture machine on similar lines due to his expertise, but with better design and features. Do you think he's at risk by copying it? Your views.
Generally, it's a good question. So generally, what happens is that companies who have patented products, first of all, it's not always easy for them to track every single competitor in the market. Sometimes it's not worth it also. If you have a very small competitor who has small volumes, is not really a big threat to you, your cost of prosecuting that guy may be more than the benefit of stopping him. So in general, companies tend to prosecute others either if they are very, very active in prosecution. Maybe a company like Gillette prosecutes lots of companies, or they wait to see if you really become a sizable threat. Otherwise, they may not do it. So I think by sort of just hearing the question, if this friend volumes are small and he is not really taking away sizable income from the patent holders, in the short run, nothing may happen to him. If he becomes bigger, yes, he might be targeted by the patent holders.
Okay, so should I go to the other question?
Yes, please.
Another one is, this is from Dhananjay Singh. He says, experts say WIPO is weak since it does not have enforcement mechanism unlike TRIPS under WTO. How does it impact the future of IPR landscape?
See, the challenge is that, patents are a matter of national sovereignty. Every country has the right to have its own patent laws. Though, of course, over time there have been some harmonization thanks to TRIPS and other agreements. So I think it's difficult to force countries to completely align their patent laws. You can see that even in India, right? So our compulsory licensing provisions, our provisions, we have some narrower definitions of novelty when it comes to drugs. We have been trying to prevent evergreening. By and large, these provisions have still been maintained, even though a lot of companies and other countries are not happy about them. So WIPO doesn't have any, cannot override or overrule national sovereignty. And I think that is, part of the whole thing. So TRIPS agreement, yes, certainly influenced the patent law, but once your patent law is being broadly compliant with TRIPS, then I don't think WIPO can do much. So I mean that's just the way the system is designed. WIPO provides other useful services like supporting the patent cooperation treaty and allowing for centralized examination and so on. But I don't think it's meant as an entity which will take action against anybody. Yeah, next question.
It does international dispute resolution through arbitration and mediation.
Yeah, that's fine. Sure, good.
Next one, I think there's one more question. What is the role of border agencies like customs in enforcement of IPRs when goods are imported or exported from India? Role of border agencies like customs.
Yeah, I think, well, to be honest, I don't know the exact answer to that question. They can sometimes be involved, but the patent law largely depends on companies challenging each other rather than depending on customs agents and so on. Sometimes I think if there is a particular issue, customs might be asked to look at it, but otherwise, in general, to best of my knowledge, and I'm stand subject to correction, customs doesn't get too much involved in IPR issues. They get involved in other things like counterfeits, fakes, and so on, but not so much in core IPR issues.
Why Indian inventors are going to patent for US or Australia and not in India? This is from Venkata.
I don't know whether they are going to patent for those countries. What they're probably doing is trying to see where they will get better value for their invention. See, in the US, there is a vibrant market for technology and IPR, which simply doesn't exist in India. So if you have a genuinely new idea and it has commercial potential, first of all, you might be better off being located in one of those countries where the technology markets are more vibrant. Second thing is you might actually be able to defend and take care of your technology better in those countries where IPR enforcement is also better. So I think it all depends on the kind of idea you have, and particularly if you're in any of these new high-tech domains, you may not get much value out of that innovation in India. If you really want to get significant value, you'll have to go to those markets where that invention is valued. And then, of course, obviously, you'll also have to take IP protection in those countries. And Indian IP protection won't help you there.
I think that is the last question so far as now. Anybody has any question? Or maybe you're getting alerted toward lunchtime.
Yeah, that's
fine. Maybe.
So everybody understood everything I said. I'm happy. It's fine.
Yeah, and that was really a wonderful session, Professor Krishnan. Thank you so much for giving your time and such wonderful insights and a very specific perspective from the management domain. Because I took a pre-FTP survey and sort of a brainstorming session. I just wanted to ask them what are the things you're looking towards to these participants. They are 90% faculties and some of them are research scholars. So their main concern was getting an insight from the management perspective. So I think you went upon it very nicely and you have left them with a lot of thinking to do further. So there's already thanks are coming up.
Yeah, thank you. Actually, see, luckily that's what I know. See, I'm not an IP lawyer. I'm not trained from the legal side. What I focus on is the link between IP and management. So
exactly.
That's what I shared with them.
Yeah, things will always remain open-ended. Thank you so much.
Okay, good. Thank you. Thanks for inviting me. All the best for the rest of your
sir.
program.
Thank you.
Sure.